legality. In other words, trying to get somebody, let's say, to buy marijuana or something, and you're trying to go to court and sue them and say, well, you still owe me for that marijuana. Well, how do you think that's going to work? Well, that's an illegal contract, so it's not going to work. Unconscionability, I see a lot of this with some of these used car dealers. It still goes on. If anything, it's worse than ever. I used to see a lot of places, I'm trying to word this carefully, but there's used car dealerships where you can get financing right at the dealership for a used car. Well, a lot of time, the true value for that car, maybe let's say it's $2,500, and so you pay like $250 down, and then you pay every week like $90. Well, the car, maybe when it's all said and done, you will end up paying these people $7,500 or 3 times the value of that automobile. So, that can be somewhat unconscionable. We've had cases where people have gotten these cars. It's funny, but some of them have left my hometown, these used car dealers, because they had so many bad stories about junk cars that people bought that would lock up when they got them home. The transmission locked up, the car wouldn't go, and so this is what you call an unconscionable contract, that the seller knew that this car had a lot of problems with it, and the money that was being required to be paid was way in excess of the value, but they were kind of preying on poor people that couldn't get any credit anywhere just so they could get a car. So there's hidden risk-shifting provisions, or there's adhesion contracts where it's just the interest rate is so high, the pricing is so high that you're trying to take advantage. Well, I mentioned earlier the statute of frauds that can be brought into play. It's usually promises for purchase of goods of more than $500, or it's really $500 or more, have to be in writing. Well, like I said, there are some exceptions to that, like those situations of detrimental reliance, but in most cases, anything over $500, $500 or more, I keep saying that wrong, have to be in writing. And this is true of interest in land, promises that cannot be performed within 1 year. It's also true of promise in consideration of marriage, has to be in writing. Okay, promise to answer for the debt of another. So in other words, you're going to co-sign for somebody. Well, you have to sign. That's the whole idea of co-sign, is it has to be in writing. So if you promise to pay somebody's bills, that has to be in writing. Also, promises by an executor or administrator of an estate that's going to pay money out of his own pocket. So in other words, let's say the executor's kind of embarrassed because something went wrong. Well, he can take it upon himself to make it right, but that has to be in writing. So we'll cover this once more because it's very important. Promises by executors to answer for debts out of their own funds. Promise to answer for the debt of another person. Once again, the old co-signer has to be in writing. Promises in consideration of marriage. In other words, I'll plow your field if you'll marry me. Sounds crazy, but stuff like that happened in the past, like in the 19th century. Has to be in writing. Contracts for interest in land. In other words, you want to sell land to somebody, you want to deed that land to somebody, that has to always be in writing, okay, and it needs to be detailed. Promises that require more than 1 year. In other words, you're going to build a bridge for somebody that's going to take 2 or 3 years, like the Brooklyn Bridge or something. That has to be in writing because it's going to take more than 1 year. And then last and probably most importantly, really purchase of goods for more than $500. $500 or more. So anything $500 or more has to be in writing. There has to be some kind of a bill of sale if it's for cash. There has to be a security agreement if it's for some kind of a contract. So whichever way you go on that, you have to have everything in writing. Rights and duties of non-parties. This is also important. Third-party beneficiaries to contracts. It's very important that you, have a promisor, a promisee, and then there is a different beneficiary. So in other words, Grandpa is going to buy a car for his grandson. Okay, that's an issue. So in other words, it's really the deal is between promisee and promisor, but the car is going to be put in the name of the grandson. Okay. You can also assign rights. The obligor's duty will change if you assign your rights. So in other words, person that's going to sell an automobile, it's another way to do it by assignment. You can say, well, I was going to have you sell me that car, but instead I want you to title it in my grandson's name. So assignment of rights, another way to go on this. Sometimes assignments are prohibited by law. Here again, let's say that child's 15 years old and you want to put that vehicle in that young man's name, might be problematic. Also can be prohibited by contract. Now you get into some things here, because back in the old days, matter of fact, my mom and dad's house, I looked at their title work. This was in the 1950s and it was in Indiana, but it said no blacks could own a home in this town unless they were like a servant, like a butler or basically manservant or a maid or something like that. No blacks could own. They couldn't even live in the house unless they were working in servitude. This is in like 1958 in Indiana, of all places. Well, those would be unenforceable. You can't make those kind of contractual terms. And so that would be prohibited by law based on the 14th Amendment, Equal Protection Clause. So basically, some things like that that you might see from time to time are not going to be allowed. Also assignments, you can assign different things, wages. For example, a lot of guys nowadays, which is funny because they really resisted this in the beginning, but a lot of guys today will just go ahead and have their child support taken right out of their check so they don't forget to pay it. So, that can be an issue where you've got, it's kind of like a garnishment, but it's not a garnishment. It's similar, but it's not the same. It's an assignment, and that's different than a garnishment. And you can have an assignment and you can have a garnishment both. I've had people say, well, you can't garnish my pay because I'm already have my child support taken out. Well, that doesn't work. You're going to actually end up with probably no paycheck, because an assignment is not a garnishment. Very important. If you assign your pay to pay your child support, that does not protect you from garnishment. A lot of people get that mixed up. Rights and duties, again, continued delegation of duties. Some duties can be subject to delegation, but what if it's an artist? You know a certain artist and you want him to prepare a sculpture or a painting for you, and the guy says, well, I'm just too busy, I'm just too full up right now, and so basically I'm going to assign it to my young apprentice. Well, that's not going to work, because they weren't hiring young apprentice, they're hiring Michelangelo. So some duties cannot be delegated like that. So very important that we make ourselves clear on that in the contract. If you leave it open that a person could delegate that to someone, then that could cause you problems. Rights and liabilities of parties. Remember that there's an obligee and an obligor, which is a contractor, contractee, and then you can have a person that delegates certain responsibilities to another person, which would be the delegate. Construction and interpretation. Basically, you want to first look at the overall or the whole of the contract, trying to make sure you understand the words, and you're basically trying to go with the most ordinary meaning of these words. There are also to be written or typed provisions. that have basically control over printed ones. So in other words, if there's a conflict and there's a typed contract and someone has written stuff in the margin, and then it's not been, the old written part, typed part, hasn't been marked out and initialed by both sides, then the typed part will control. So just because somebody writes something in the margins or in between the lines, that's not going to control. The actual type provisions that are typed in the contract are going to be more responsible than something that you print in alongside with a pen, unless it's very clear that both sides agreed on those changes, marked out the old, and initialed the new, and that's my initials. PRD would be my initials, okay? So if that's not on there, both sides have to have their initials on there. Then they have to make it clear so the next person that comes along can look, which is generally going to be a judge. So that's important to make sure your contract's clear. Also, custom and usage. You can see that people do different things with different contracts and communities and so forth. So you can actually have witnesses testify as to what that usually means. Parol evidence is to try to be avoided as much as possible. If someone intended for a written contract to be the full, complete, and final expression of their agreement, then they cannot be changed by parole oral evidence, or in other words, someone said, well, I wanted to change this or something like that, and he agreed to me orally that he would agree to change it, but it's never been put in writing. Well, then you can't use that. You're going to have to go with the written form. Parole evidence may be used in certain situations when it comes to allegations of fraud, duress, mistake, clarifying ambiguities, refuting a written recitation that there has been consideration when there was no consideration, or sometimes subsequent negotiations, can come into play, that there was intent to amend that contract, and that perhaps there is a written amendment out there, but nobody can find it now. I mean, those are situations that can come up and can be problematic. Enforcement of contracts, we want to look at promise versus conditions. You've got to look at both sides, the promise and any conditions. In other words, there can be hindrances, there can be breaches. Someone didn't pay when they were supposed to pay, so the person stopped working, for example. Or perhaps, let's say, the weather is bad, so that can be a problem. If you're building a house, for example, and you said, well, I'll get it built by such date, but it's not built by that date. Also look at waiver and estoppel. In other words, if the contract calls for certain actions within a certain number of days, so if you don't like this, you've got to let me know in 30 days, and it's 45 days, then you basically waived your right to complain. Okay, performance. Remember, illegality. Basically, you're going to sell somebody drugs, or let's say you're going to sell their children, something like that. You cannot engage in any kind of contract that involves illegality. Sometimes these are pretty stark examples, but you can get into smaller examples like EPA violations, things like that, pollution, things that you cannot do, violation of zoning laws. These can all be different forms of illegality. Impossibility. Let's say somebody's supposed to paint your house in Florida, and there's a sinkhole that comes up, and that house, disappears into a river down below and is washed away. Well, it's impossible to paint that house. Okay, well, you got to turn the guy, give his money back then if he made a down payment. There's also frustration where somebody's caused the subcontractor so much grief. No, this is not right. I want to change it. This, that, the other thing. Just different issues that have come up. Release of contract. and accord and satisfaction. If there's a written statement signed by the parties that, yeah, this is all done, it's over, accord and satisfaction, that means, hey, this contract's paid, the work's done, everything's finished, so don't worry about it. Also, operation of law. If there's something that came up that said, well, no, this can't be done anyway according to the law, so then basically the contract is canceled. There are breaches of contract. These can include material breaches, so in other words, man, this thing is completely wrong. Minor breaches, hey, there's some few small things here I don't think are quite right, need to be fixed. Timely performance, someone's got to get something done within a certain calendar time period, like a year, and they don't get it done in a year. Then they come back and say, well, yes, but the weather was worse than we expected, so we weren't able to work inside. Just different things like that. There are remedies. Contract remedies include damages. These can be compensatory. These are basically general damages that relate to something that would be normal, expected. Consequential damages are where something new happens. Let's say somebody gets injured on something that was done for them in the form of a contract, and then basically they have to have doctor bills paid as a result of something that happened. Wasn't directly related, but it springs out of the contract. Punitive damages, where you're doing something that's so bad, so terrible that you ought to be punished for it. Punitive damages mean punishment damages. Nominal damages can be very small, like $1. Liquidation, can be, well, we're going to sell this off, see what it brings, and then the person that's been harmed will obtain or get the outcome of the sale of the liquidation. Other damages, sale of goods. Seller can have remedies including withholding delivery, stopping delivery, reselling goods, recover the difference, cancel contract, recover the contract price. In other words, sue the person for the contract, recover some type of ordinary damages, cancel, again, like I say, buyer's remedies, cancel, cover, in other words, go out somewhere, get the goods that you were expecting, pay that other person, and say, okay, well, this is all taken care of, but you're not getting the rest of your money because you didn't deliver. I had to have somebody else deliver. You can require the person to turn over, where let's say it's a piece of artwork, and the person was obligated to give it to you for X dollars. You paid the X dollars, they don't turn over the Michelangelo painting. Then that's where you can try to recover the actual specific performance, which is give me that painting. I want that painting, not some other painting. There's also a possibility of damages for non-delivery. Let's say you're planning on getting goods like fireworks. Here it's the 4th of July, so you're getting fireworks that you want to set off as a part of a celebration. Well, that's important, okay? Got to be delivered in time for you to sell them to make a profit. Okay, well, moving on, sale of land. There can be construction of certain contracts there. There's always equity in contracts. Specific performance, I mentioned. Rescission and restitution, someone paid, but the person can't deliver, so they deserve to get their money back. Also, contracts can evolve into tort claims, where let's say someone's injured on the job or something. This can result in somebody having a lawsuit. So basically that's it on these terms. Hope you enjoyed this. I know it's a little bit dry. Tried to spice it up. I'm kind of at a disadvantage being down here. Hope to get me a whiteboard eventually and be able to do presentations here just like I do back in my classroom. But we'll work on that, and hope that you got something out of this. Main thing is to go over it. You can record this if you want to, listen to it again in the future, or you can do your own recording of your own rendering of definitions, vocabulary, things like that. So let me know if I can help you. Again, robdawalt@me.com. Thanks. Bye.